Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson.
Disorderly.
Your Honor, I don't know if for Douglas and people, Your Honor, I don't know if Your Honor had a chance to sign the referral and if that paperwork.
I have the referral that I will sign off on, but I don't have a plea form. I don't have anything.
Then we aren't ready for it, because we needed you to sign it, so that's what we needed.
Yeah, that was the one thing I was waiting on. Was hoping we could do it this morning, but I don't obviously mind
Do
passing.
what this morning?
Sign the plea form. That was the only thing that was not prepared.
I'll kind of need that.
I was hopeful that Ms. Douglas could.
Okay, what am I doing? Because otherwise I'm just gonna do what I'm gonna do.
I have an email at 9 a.m. with maybe the information that you're looking for. I don't know.
At 9 o'clock this morning?
Yes, I have not reviewed it over.
So Your Honor, we were trying to get him referred to Veterans Court. I had not received confirmation that he'd been accepted, and that's why I didn't do the plea form, because he needed paperwork.
No, I got you, because I just signed off on the referral. So I can't really do anything.
And I apologize, Your Honor. I was under the assumption that the emails that I had provided from Mr. Graveline stating that he had been accepted into the court and that this was going to be pled today was going to be sufficient, but
Probable cause in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. You guys get your stuff together and then I'll deal with it.
Thank you, Judge.
Court does call the case, People versus Larry Hickman.
Judge Kennedy, after people, Your Honor.
This was the.
Yes.
Good morning, Your Honor. Student attorney requesting Andra Savvy requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli, representing Mr. Hickman, who is present in person today.
Permission to practice is granted.
Thank you, Your Honor.
I
Your
guess
Honor.
the first thing we need to take care of is there were additional counts added, counts 3 and 4. I think we got the counts straight. Have you reviewed those with your client?
I believe Ms. Ikiri Akinruli has reviewed those counts with Mr. Hickman. Yes, sir. No. The knee count, were they reviewed with you yesterday? No. No?
Where is Miss Akinruli then?
I'm not sure, Your Honor. I believe she may be in another courtroom at this time.
Well, has anybody gone through the other counts with him that were authorized? Or you don't know? Or you don't know?
If
I'll
just
take
have
that
the
as
court's-
that I don't know. Huh?
Yeah, I apologize, Your Honor. I cannot provide an answer to
You
that at
take
this
it
time.
back. I'll pass the matter. We'll have to bring him out later.
Okay.
Gonna have to go through those other counts. The court does call the case of the People versus Brandon Clemens.
Answer that.
Good morning, Your Honor. Attorney Jonathan Paul for Mr. Clemens.
Clemens, can you state your name, please?
Sir, Brandon Clemens.
And I'm gonna. That's okay. My copy.
Yeah, it's a.
Okay, thank you. All right.
I wasn't sure you were going to be able to do it.
That's the one report that I got
Yes.
last minute. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilt. Well, is he going to be pleading guilty or no contest? Because otherwise I've wasted my time reviewing a plea.
Your Honor, he's pleading guilty.
Pleading guilty to the charge of operating while intoxicated with an occupant less than 16, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that
Yes.
correct?
Yes, sir, that's correct.
Yes, Your Honor.
Mr. Clemens, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir. Yes, Your Honor.
State your name again for the record.
Brandon Clemens.
Put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor. Yes, Your Honor.
All right. And understanding all of that, well, and I'll also indicate to you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge. Need a name? Before Judge Perry in the 15th District Court. Do you understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor. Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Pardon?
I currently have a sober breathalyzer.
You're not.
Right. Are you under the jurisdiction of any other court, sir?
No, Your Honor.
All right. Have you ever been to prison for longer than a year?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor. No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor. Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor. Yes, Your Honor.
All right. And you understand that if you commit any type of misconduct between the time of this plea and the time of sentencing, that you would not be entitled to withdraw your plea unless allowed by the court for a good cause. You understand that?
Yes, Your Honor.
You also understand, sir, that if you do commit misconduct during that time, the sentencing judge would not be bound by any recommendation or evaluation.
Yes, Your Honor. Yes, Your Honor.
Is counsel aware of any other pleas, inducements, or threats that have led to this plea?
No, Your Honor.
No, Your Honor.
Counsel, I didn't hear you.
No, Your Honor.
All right. Sir, on the date of April 3rd, 2024, at the location of Liberty Street near Maple Road in the city of Ann Arbor, Washington County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor. Yes, Your Honor.
What did you have and how much?
I had drank heavily the night before, and then the day of that morning, I had about 2 twisted teas. So I think my blood alcohol was mostly from the night before of me drinking heavily.
Were you stopped by the police or was there an accident?
I was stopped by the police. There was
Why did they stop you?
I did bump a little bucket inside of the store, but they stopped me because of the driving that they had witnessed.
Are you disputing the right of the police to stop you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station or the hospital?
I was taken to the station, Your Honor.
Was there a data master or breathalyzer test of some type?
Not on my end, Your Honor. They took me to the police station, and then later they took me to
Counsel,
the
was there a
hospital.
breath test or a blood test in this case?
Your Honor, it was a
Your Honor,
blood
there's
test
a
of
blood draw. I have the
0.248.
labs.
Did you take a blood test, sir?
Yes, Your Honor.
What were the results of that blood test?
0.248, Your Honor.
0.248? Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Was there an occupant in that vehicle
You broke up, Your
besides
Honor.
you?
Yes,
Pardon?
there was another occupant in the car, Your Honor.
Who was that?
That was my girlfriend's son.
And how old is he?
He is currently 6.
At the time, how old was he?
He would have been 5 years old, Your Honor.
Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. People
Yes, Your
accept
Honor.
Court will accept the defendant's plea. 2 count 2, count 1 is dismissed. The pre-sentence investigation and screening and assessment is ordered at 15th District Court. Sentencing in this matter will be July 14th, 2025, 8:30 before Judge Perry.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you.
You can sign off, Brandon.
Thanks.
Court calls the case of the people versus Michael Patterson.
District Kennedy, active people, Your Honor.
I have 2 cases.
Carry on.
Second, really? Hang on a second.
Good morning, Your Honor.
Pardon?
I said, good morning, Your Honor.
Not really, but thanks. Moving to you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patterson. Today is the date and time set for the probable cause conference, Your Honor.
Yes, in both matters.
Set up a preliminary examination.
What's that?
Set up a preliminary examination covers the officers.
Oh, that's from the prosecutor?
Yes.
The hospital. So today, I would like to be concluded from this situation, in this case, just to be further admitted into the psychiatric hospital. He already ordained that.
We'll do that as part of the bond.
All
Your
right.
Honor, today, there are no offers from the prosecution. My client will respectfully request that this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
You want preliminary examination in both cases, sir?
Yes, please.
To your knowledge, I'll discover is complete.
To my knowledge, yes.
People have their witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor. As to bond, we're
As to bond.
asking for a modification. My client indicates that he has already been determined to be released to, what was it?
I'm sorry?
To Havenwick, on Arbor Hills, Havenwick Hospital for psychiatric treatment.
Arborwick, Haven Hills Hospital. We're asking that his bond in these cases allow him that similar release to, what's saying the name of it again, please?
To Auburn Hills, Havenwick Hospital.
Auburn Hills, Haven.
For
Hospital.
treatment?
Yes, please.
And you say he has that in his other cases or?
Yes, the last time I was here, that's what I was before you, Judge Simpson, and
Yeah.
you ordered for me to go there.
I think I ordered release to inpatient treatment.
That's right. That's what I want.
But I think did we already order it?
Well, it sounds to me like.
Yeah, on my last court date, that's what was that was ordered by you personally.
Okay, I don't have an order. If it's a release to inpatient treatment, I am not going to have an objection whatsoever. So where's Ms. Yagi? Ms. Yagi has an order that she has prepared that probably all of the public defenders should use. That I'd be more than happy to sign off on, that I've signed off on for the last 5 to 10 times for her.
I know Ms.
So-
Yagi will happily share,
Mr. Patterson.
Thank you, Ms. Yagi.
because we are one happy family.
I don't know about all that. All right, so at this point, what I'll do is his bond will continue. And once I receive that order, I'll sign off on it.
Thank you very much. Your Honor.
All right, thank you.
Thank you, brother.
You're welcome.
Okay, I think we've been in the shape in. Court calls the case, People versus Mary Collins.
Andrew Bennett for the people. Good morning, Judge Caldwell, on behalf of Mary Collins, who is approaching the podium. And Mrs. Collins, please introduce yourself to the court.
I'm Mary Collins.
Thank you.
And your Honor, today's the date and time set for probable cause conference. I have spoken to Prosecutor Banis. We are working on a resolution. I do have a adjournment form for the court's file.
Case, sir.
Probable cause conference in this matter will be adjourned to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Court does call the case, People versus Lakita Roberts.
Andrew Banis.
Have you start working.
Hannah Mackey on behalf of Ms. Lakita, who's approaching to my right. Please state your name for the
Lakita
record.
Roberts.
Your Honor, we're respectfully requesting an adjournment. We believe that we could discuss a possible global resolution in her circuit court matter as well.
So she has things in circuit court.
She does, Your Honor.
And when's her next date in circuit?
Don't know that
If
one.
you're gonna do a global resolution, don't you think you should know that? I'll wait.
Your Honor. I see a case, according to X jail, a circuit case scheduled for 6/25, June 25th.
June 25th, Your Honor, is the date.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond continue.
Thank you.
Court calls the case of the People versus Bianca Rao.
However, on behalf of Ms. Rowell, who's approaching the podium. Ms. Rowell, please say your name for the record.
Bianca Rao.
So, thank you, Your Honor. So we are, today is the date and time for probable cause conference. We have worked out a resolution. I've provided documents to the prosecutor, Mr. Banis, today, and I have a few more that I'm going to email that Ms. Rowell provided for me today. We just need to have first APA, Burton Harris, look at these documents. So we are asking for a brief adjournment, hopefully the last.
Probable cause conference will be adjourned July 3rd, 2025.
Thank you, Judge.
9 a.m. Bond continued. Court calls case People versus Thomas Vasher.
Andrew Van.
Not present.
And Alex Warren Green on behalf of Mr. Vasher. Mr. Vasher, can you state your name for the court?
Thomas Vasher. Are we gonna get breakout room or something?
Oh, Your Honor, I went to the jail last night and
Yes, you did. He wasn't there. He's in the hospital.
he has been transported to the hospital.
Yes.
So I'm asking for an adjournment. The people generously did extend an offer. I want to discuss that with Mr. Vasher. And if I may ask on the record, Mr.
Now-
Vasher, do you anticipate when you'll be discharged and returned to the jail?
No, actually, they just talked to me and I plan on staying here. They need to run
Okay, well,
different tests.
Mr.
and see why
Vasher, call the
legs are-
public defender's office if you can. And Your
Well,
Honor,
how
I'm
come
respectfully asking
breakout room and
for
you
an
can
adjournment.
explain, or can you address my bond at least? Because I'm here on my bond's been violated because you guys
Mr. Vasher,
while I was out.
Your Honor, I'm requesting an adjournment to the next available
well,
date so
can
I can talk
To
to
address
him.
my bond. I'm asking you that.
I'll give him an early date. That way you can go talk to him and see exactly what it is his complaint is. June 26, 2025, 9 a.m. Bond continues.
Thank you, Your
I'm gonna
Honor.
I want a new counsel.
Court calls case People versus Julius Holston.
Okay, friends, good morning once again. Welcome to the Courtroom Files Live. So normally by now I would head someplace else, but things are edgy here at Judge Simpson's court. So put a 1 in the chat if you want to hang here a little longer. Put a 2 in the chat if you'd like me to go to another court.
Good morning, Your Honor. Julie's host.
There was a resolution that was worked out this morning. It would be a no contest plea. I have a plea form if the court's able to allow that. Otherwise, we'd be asking for an adjournment.
No contest. I haven't even read a report.
I understand.
They're supposed to get to me at least 24 hours. I don't mind doing the work, but I'm not going to do it on this day.
Okay.
So I'm going to put it over and then I'll take your plea.
Okay.
But I'm not going to do it. I'm not doing that today.
That sounds like a plan.
Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Demarius Tubbs.
Andrew Bennett.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Demarius Tubbs. Mr. Tubbs, please state your full name for the record.
Demarius Tubbs. All right, first order of business is I need a substitution of attorney filed. Mr. Martell, I'll let you go ahead. I realize you filed an appearance, but I think you know the court rules require a substitution of attorney.
Yes, Judge.
All right, what are we doing today on this?
Judge, it was my expectation that charges would be filed federally by now. I have not received any. So, Judge, discovery is complete. I'm asking for an examination date, please and thank you.
I didn't hear any of that. You need a better microphone.
Forgive me, Judge. Discovery is complete. We're asking for a preliminary examination date.
People have their witnesses available July 1st.
We will do our best, Your Honor.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Always a pleasure. Have a great day.
Court calls case People versus James Chandler.
Alexander, on behalf of the people, Your Honor.
And good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record? James Chandler.
Where's the rest of his pants?
I was at work. He was at work, Your Honor.
Really?
And that's and one thing about it is my apology. I had told him it was going to be 2 p.m. and once I seen he was on the 9 a.m. docket, I called him later. He hurried up and got up to
And so what, his pants weren't ready or what?
he probably didn't have any pants where he was.
I see. Oh. Okay.
But now that
It won't happen again, right?
never again.
Yeah, okay, go ahead.
Okay, today we're
Sir,
gonna
that's not your fault, it's his. Yeah, don't worry about it.
it is.
I know, everybody knows it's your fault.
I take full
All right.
responsibility. Now we're just asking for a slight adjournment because the prosecutor needs to check to see if the body cam has audio, Your Honor.
That's correct, Your Honor. Media's been provided, but it's my understanding that Mr. Bird's media doesn't have audio, so I need to check in if there is audio on the videos.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Did you fill out a green form?
I did, Your Honor.
All right, yay.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Philip Brown.
Regardless for the people.
Okay, where's Burgess?
He's here.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Philip Brown.
All right, what are we doing?
Your Honor, this was a reissue. I have had discoveries for some time, so we're requesting an exam in this matter.
People have witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Barr.
Judge, may I briefly address the issue, bond?
You may.
Thank you, Your Honor. Your Honor, bond is currently set at $250,000 cash surety in this case. Understand the serious nature of the charges, but the allegations are that the complainants in this case ran up into my client's girlfriend's house where he was staying. The police report is somewhat vague on whether the incident occurred outside or inside the residence, but be that as it may, Your Honor, on my client's actions, we do take the position that my client was acting in self-defense of himself, his girlfriend, and her home. And all three witnesses on the case before didn't appear at the last exam, Your Honor, after speaking respectively to their counsel, which they needed appointed because of their potential Fifth Amendment issues. So based on that situation, Your Honor, I think that the bond should be lowered, maybe 50,000, 10%. My client didn't want me to ask for a PR bond. I know the charges are serious, but I do think under the circumstances, the bond's excessive. Thank you, Judge.
Response.
I believe that the bond is appropriate. The report is not vague about where this took place. The allegation is not that these people ran up in the house, it's that they did go to the house, and that this occurred outside, and that a neighbor who was uninvolved witnessed part of this, and it was the reason she was able to witness it is because it happened outside. And so, Your Honor, there's the allegation that he shot at 3 different people in the front yard. As far as the cases, 2 witnesses that were able to be contacted for the exam when this was initially issued did want to move forward. They were not able to come on that date. And so the people were unable to get an adjournment. And that's why there was a dismissal and immediate reissue. It's not that they didn't want to move forward. So, Your Honor, we do believe that this bond is appropriate.
Who was this case originally before?
Judge Washington? Yes. Judge Washington, I believe, yeah.
But no testimony was heard?
Correct, Your Honor. We've adjourned it a few times for them to
Then
speak to counsel.
I'll leave it before. All right. Anything else?
Yeah, only that the 3 people that came to the house came uninvited, and this was over a dispute, so they were coming there, obviously.
Were they armed?
Yes, Your Honor.
Your Honor, there was one individual who admitted to having a firearm. However, he is not accused of trying to shoot him.
Only accused of bringing a gun to a stranger's house without permission. Yeah. I believe there was an AR-15, Your Honor. That's a semi-automatic rifle.
Firearm.
But there are 3 felony firearm charges here at the 3 in possession of the allegations that he's a prohibited person, so he shouldn't have a firearm or ammunition. And then I have 1, 2, 3 counts of assault with intent to murder and assault with intent to do great bodily harm less than murder and carrying concealed. All right. Anything else from either side?
Your Honor, there was one minor. There was a no contact issue to his girlfriend, Latrice Hargrove, when he was rearranged on this case. That had been lifted last time. It was a confusion as to that. She's just his girlfriend, not a complaining witness to the case. I just asked that he be allowed to have contact with her. She'd be a defense witness in this case.
Any response to the no contact?
Your Honor, she is a witness in this case. I believe that the no contact was issued because part of the conflict is supposed to have been based on allegation that Mr. Brown had done something to her daughter, but I will leave that discussion.
Okay, I'm not gonna change the no contact. I'm gonna leave that where it is at this point. I'm also gonna deny the defendant's motion for a bond reduction. Bond will continue. Thank you.
So if you need another copy, so. Okay.
That's called the case of People versus Leorn McEwen.
Yes, Your Honor. Please, this honorable court again, Brandon Byrd on behalf of Leon McEwen. Mr. McEwen, can you please state your full name for the record? Please.
Thank you. All right, what are we doing?
I would really like to get this resolved, Your Honor. But if Sister Prosecutor doesn't believe that we can get this resolved, then we're gonna set this matter for exam.
You have all the discovery.
I do have all the discovery.
People have their witnesses available to first. You need to take, sir, you need to hand out.
Oh, I'm sorry.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Just for the record, the offer has been that if Mr. McEwen could provide proof that he could drug treatment, the date of offense, that he'd be offered a use, however, that apparently is not.
I say anything? I've been in treatment for 5 years. This case is 5 years old. So is there any way we could adjourn this matter, Your Honor, to provide Sister Prosecutor?
I passed all my drug tests, every one of them.
I need a green sheet. Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Thank you. July 3rd.
Okay, sir. Thank you.
Thank you, Your Honor. Thank you for your patience today,
Thank
too.
you, sir.
What?
Thank you for your patience today.
Oh, no, that's really not in the cards. Thank you. Court does call the case, People versus Todd Rayberg. Now you get it. All three
Morning,
cases.
Your Honor, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Rayberg. And Your Honor, I do have some paperwork here. I just had it. Mr. Rayberg, could you state your name for the court?
Todd Rayberg.
Swear I had it, Your Honor. Here it is. I am requesting a brief adjournment. One of these cases is very new and I didn't have the police report yesterday when I met with Mr. Rayberg. I'm also submitting to the court a proposed release to treatment order if the court would consider signing it.
Any objection to release the treatment from the people?
There's no objection.
I'll sign that order. And then I'll grant the adjournment in this matter on the 6th, which is going to be a day from where you want the 3rd.
I think probably the 3rd, Your Honor.
Good enough.
Thank you.
So probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will.
Thank you.
Court does call the case, People versus Adam Fari. This is the one.
Oh, different.
No, it's one.
Right, the people put their appearance on the record. Joe Simon, you did, right? Sorry, Joe Simon on behalf of defendant Mr. Bari, state your name.
Adam Bari.
All right. You need an adjournment in this case.
Yes, I'm going to supply some mitigation documents to the people in support of a
I
request.
think July 10th was,
I will be back, Your Honor, but you may be seeing too much of me on that particular day.
oh, I'm seeing too much of you every day.
So either the 10th or the 17th, but I have, sometimes the court gets mad
Conference,
when he sees too
July,
much of me.
July 10th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you.
Or if you want to wait for me.
Court does call the case of the people versus Mohammed Dar.
Say it again. Yeah, actually.
Assistant Public Defender Costinville based on behalf of Mohammed Dar, who is present to my right. Mr. Dar, could you state your full name for the record?
Mohammed Hassan Dar.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, there is no offer, so we'll be requesting to set this for a preliminary exam at the soonest available date.
You have all discovery.
To my knowledge, Your Honor.
People have their witnesses available the first.
Do our best, Your Honor.
Preliminary examination in person, July 1st, 2025,
Your Honor, may I just bond when
9
appropriate?
a.m. Yes,
Your Honor, my client is requesting a PR bond. He has two jobs on the outside that he would like to keep. This is in a group home. He supports his mother financially by sending her money. He also has some personal matters that he needs to be taken care of on the outside. I don't believe he's a further danger, Your Honor, if the court is inclined to give him a GPS tether or put in the no contact, no go-to orders. He's willing to do whatever the court deems necessary, Your Honor.
Anything.
respond.
I object to any modification of bond at this time. My understanding, Your Honor, is that the defendant was currently on bond at a case out of the 15th District Court. Failed to appear at that case while he was hospitalized, which is where this offense took place. In this present matter, the defendant assaulted a nurse by grabbing her right breast, and she was placing a blanket on him. I object to the modification.
Well, we certainly understand how serious the allegations are, Your Honor. As I said, my client is open to any no go-to, no contact orders, anything the court deems appropriate. We don't believe that he's a further ongoing danger to the community nor a flight risk, Your Honor, at this time.
His bond is set at this point at $1,000 cash surety. So I think that's appropriate given the allegations in this case. Motion for bond reduction is denied. Bond will continue.
What was that date, Your Honor, for the
July 1st.
Thank you.
Thank you, Your Honor.
All right, we should probably check out somebody else. We've lingered there for about 40 minutes or so, which is probably a record for this show. If you're new to us, we tend to move around here a lot more than other places do, but Judge was cranky this morning, so we hung there for a little extra time. Let's go to Florida. This is Judge Anna Garcia, and she is addressing felony matters this morning.
Promised you anything different to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No, ma'am.
All right. I have in front of me a 2-page plea waiver and consent form. This is the first page. This is the second page. Did you sign that document right there on the second page?
Yes, ma'am.
Did you have enough time to review the document before you signed it?
Yes, ma'am.
Did you have enough time to talk to Mr. Graham about your case and about whether or not to plead?
Yes, ma'am.
Are you satisfied with the advice and counsel that you have received thus far?
Yes, ma'am.
Do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove the allegations against you?
Yes, ma'am.
Do you understand that you are giving up your right to present any defenses that you may have to the allegations?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence of this court? Are you doing this of your own free will?
Yes, ma'am.
Mr. Alday, I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of said plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Alday, in Jackson County case number 24 CF 596, I accept your plea of no contest to 1/3 degree felony count of resisting with violence. I will withhold adjudication of guilt and sentence you to serve 36 months state probation. During that time, you are ordered to pay court costs, fines, and fees. Ladies, is it 14? Oh, well, it will be different. 1065 in the amount of $1,065. I order you to serve 100 hours of community service work. Once you have fulfilled all monetary obligations, you may buy your community service hours at whatever the current minimum wage is for the state of Florida. Or Sharon, do you guys do federal? Florida. So whatever Florida minimum wage is at the time you buy them out, whoever phone that is, guys, please turn it off, sir. And please step out and turn it off or whatever you need to do. Let's see, where was I? So you can buy it at the rate of minimum wage. You're ordered to pay $20 a month for costs of supervision. I order you to undergo a drug and alcohol evaluation and any recommended counseling. Now, if you had completed inpatient drug treatment and it has been since this arrest, then the state probation may count that as the recommended counseling. Tell me the facility where you did inpatient for 30 days.
Florida Springs.
All right, the court will allow the drug and alcohol evaluation and recommended counseling to have been through Florida Springs. Is that a DOC? Okay, so by me saying that, that will count, okay? Now, did Florida Springs recommend any subsequent counseling for you?
Well, I still do, like outpatient, I still go to outpatient therapy.
So that will continue to be required until they stop recommending it.
Well, no.
Is
like
it voluntary or recommended?
I'm going, so they had, when you go to outpatient with them, you can't go to your original therapist. They have a different therapist or whatever. But since leaving there, my actual therapist went to a different place. So I go and see him. I don't actually see Florida Springs anymore, but I still go to the therapist that I had when I was in Florida Springs.
Got it. So here's what I'm announcing, okay? If Florida Springs program recommended continue outpatient, then you're ordered to continue any continued outpatient that was required. If you are voluntarily going to outpatient, good for you, keep doing it, okay? But then it's not court ordered if it's voluntary. Does that make sense? It is important that you understand that you will be held accountable for the use of drugs or alcohol while you are on supervision, and there will be a zero tolerance policy, and you are subject to random urinalysis at your own expense. I order you to submit to a DNA sample, forfeit all items seized, and again, remind you that just like you must not consume any controlled substances, you must not consume any alcohol during your term of supervision. I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Let me say this, sir. It seems to me like you have a question and that it may be related to this continued outpatient counseling. Mr. Graham, is there any doubt in your mind what the court's order is?
No, ma'am.
I think what would be best for you, sir, is to privately speak to your attorney and he will tell you exactly how to move forward, because I don't want you to say something that may hurt you down the road here in open court. Okay? You're in competent, very capable hands, and he'll answer your questions. Before you leave this courtroom, I want you to step to the side and meet with Ms. Sharon Jernigan. She is our representative from state probation, and she will give you instructions about reporting to state probation this morning. All right? Anything further from the state or the defense?
No, Your Honor. No, ma'am.
All right. Thank you, guys. Always good to see you.
Yes, ma'am. Thank you, Judge.
All right, Amanda, we're getting Washington County. I don't see Washington County. Debbie's listening, so she knows Chris is going to get Washington County on. Do we have Upshaw? All right, go ahead. And Mr. Vereen, if you're there, wait, who's ready? Washington or Upshaw? Both. Okay, let me get Upshaw. We got Mr. Vereen. Good morning, Mr. Vereen. We've got the state of Florida versus Jerry Upshaw. I am happy for you to sound our case and proceed.
All right, good morning, Judge. This is with regard to case number 24 CF 536 CF AXMX, State of Florida versus Jerry Lee Upshaw Jr., Rod Vereen on his behalf.
Thank you. And I know Mr. Overstreet is on the line. and is here on behalf of the state of Florida, but does not have video capabilities. Mr. Overstreet, I am happy for you to announce your appearance for the record.
Good morning, Your Honor. Peter Overstreet on behalf of the state of Florida.
Excellent, thank you. Mr. Vereen, Mr. Overstreet, let me ask Mr. Vereen, how are you coming along?
Well, Judge, I'm still putting together the defense team that I need to assemble on behalf of Mr. Upshaw, but I've recently filed a motion for an Arthur hearing. I've reviewed all of the discovery that the state has provided me to date. I'm assuming there's gonna be more in the future, but at this point, I am ready to go forward with an Arthur hearing on behalf of Mr. Upshaw. I know that there are a number of that are currently in custody. I know there's going to be a number of submissions that I'm going to submit to the court in advance of the Arthur hearing because some are very long audio interviews conducted by law enforcement with these individuals, and they've made a number of statements on different occasions. And I believe that the court is going to need to have some time to review all of those statements before we proceed to an Arthur hearing, so we won't take up too much time in court. If the court, and I'm going to speak with Mr. Overstreet with regard to what he's willing to stipulate to, so we don't have to probably bring in as many witnesses, but there are going to be some witnesses that are currently in custody that I'm going to ask that be present for the Arthur hearing.
Sure. As you stand here today, I think the best way to move forward is to go ahead and put Mr. Upshaw on a pretrial at a future date. But you guys can go ahead and email my judicial assistant and get on the docket or get a special set Arthur hearing time. As you sit here today, how long do you think you'll need for the hearing?
I personally believe the hearing is going to last maybe 2 days.
Mr. Overstreet, what say you?
Well, Your Honor, based on the defense filing for an Arthur hearing, I would just file for a motion for pretrial detention. I think essentially at that point, once the court determines that on the pretrial detention motion that he's to be held without bond, it almost makes the Arthur hearing moot at that point. I also disagree with Mr. Vereen being able to call certain witnesses at the hearing because they're represented by counsel and they've not entered pleas. So, you know, there's a number of moving parts, but I honestly don't, again, I think if I file a motion for pretrial detention, it basically makes the Arthur hearing moot. Mr. Upshaw was already in custody at the time that he was indicted and had not made bonds on those charges. He's, you know, the state's currently seeking the death penalty. You know, the indictment was all the way back in October. And so at this point, at least on my end, nothing really has happened in the case. And so that's the state's position, is that the court can take up a motion for pretrial detention. And I don't even think we'd have to have an Arthur hearing at that point.
Well, yeah, I disagree with that. I know that the burdens of proof are different as far as substantial probability versus proof evident presumption great, but Mr. Overstreet has not filed that. There's nothing, you know, to prohibit Mr. Upshaw from moving forward with an Arthur hearing. And I'm not sure which witnesses Mr. Overstreet is relying on with regard to trying to even establish, you know, a substantial probability. You can't do it by way of affidavits if those individuals are represented by counsel and they are not cooperating with the state. I'm not sure what their position is, but these are, and I don't know who appeared before the grand jury in order to indict Mr. Upshaw. That has not been provided to me as of yet. So at this point, I'm ready to move forward. And I guess, Judge, we need a date with regard to an Arthur hearing. If Mr. Overstreet is going to file a pretrial detention motion, I would suggest to the court that he does that. So we can then address that once it's done. But right now, we're just, you know, shooting in the wind.
All right. So counsels, I do not have my calendar here. If you need 2 days, I am happy to have my judicial assistant email both of you 2 days. If in the interim, Mr. Overstreet, you file a motion for pretrial detention, we will certainly set a time for that and address everything as is needed. But right now, do you want to come back as soon as August for a return date in this case, or do you prefer to come back September, or October? I will give you dates.
I think August
Likely-
is, I think
You go
August
ahead.
is fine for a pretrial date, Your Honor. I can have
Okay.
the motion for pretrial detention filed probably within the next couple weeks. And I'm sorry, there's just a lot of jail noise.
I know. There's,
As
yeah.
as the court's aware, the state can file that motion and rely on affidavit and rely on hearsay. So
Guys, I know that you guys are, it sounds to me that this is the first you guys are talking about this, okay? But I don't want you to make your legal arguments about what the court can consider at those hearings and what evidence and all that. We'll do that at those hearings because I've got a courtroom full of people. This isn't my only
Yes, ma'am.
case. So I'm happy to hear, I'm happy to consider the pretrial detentions, the Arthurs, all the things, and we'll address it at another point. I just need to know when you want him back. You want him back August 12th. Let me be candid, a 2-day hearing, you will likely not get until, John Young, was it September? September. So I just don't have it unless you want to be a backup to the trial week and it's a backup. So we'll discuss all that through email with my JA. I'll let her know to reach out to you guys. In the meantime, if you file the pretrial detention, then let me know. And we'll schedule that for hearing if necessary as well. Okay?
yes, ma'am.
That's fine, Judge.
All right, guys. Is there anything else that we need to address on Mr. Upshaw's case?
No, Judge.
No, Your Honor.
Ladies, Mr. Upshaw, is he scheduled for August 12th on all his other cases anyway, like with Morris and whatnot? Because I think that's what happened today, why he wasn't on the docket is because he was tracked. It's somewhat confusing. I know we were trying to accommodate Mr. Vereen's schedule.
I think last Tuesday, I don't think Mr. Upshaw was on that docket, but we went ahead and scheduled it for a pretrial.
Is everything on August 12th right now? What is everything? And no pretrial? Let's put them all pretrial August 12th as well. Let me tell you why. Alex Morris is going to be here anyway, August 12th. We've just had a bunch of other stuff. Will you let him know, Shayla? Have your office know? And that way, because I mean, even though he's set for trial, guys, on Alex Morris's case, he's set for trial in September. But we're going to have a pretrial in August. Okay? Mr. Upshaw, I'll see you at the latest August 12th. I may see you before then, okay?
Yes, ma'am.
All right. Mr. Vereen, Mr. Overstreet, anything else on this case?
No, Your Honor. Thank you very much.
No, Your Honor. Thank you.
Thank you, guys.
All right, let's switch it up. We'll go to Texas, Jefferson County, and we'll see what's going on with Judge Stevens this morning.
One, it's an initial appearance. Are you probably intimately aware that you're charged with the 3rd-degree felony of operating a motor vehicle while intoxicated? And it's a felony because I'm showing you have at least 3 prior DWI convictions dating back to 2006 out of Harris County, and Chambers County, those 3. So every DWI that you pick up, it's a felony. So which carries with it 10 years in prison. And are you driving a vehicle now? Okay, because you can't operate one without an interlock device. Okay, somebody drives you? Okay.
Yes.
Okay. Yeah, it's initial appearance.
Yes, Judge. He has called out his new affidavit of indigency, but I do not have access to his discovery yet. If I can have a couple week resets to get my hands on the paper and the media associated with this case.
And she's going to talk with you before you leave and get some information from you and make sure that you are forthright. And then we're going to reset this for an announcement in 4 weeks. Okay, thank you. Joanna Glover, please. No answer in the courtroom. I asked the bailiff to call into the hall, please, for Joanna Glover in 25 CR 453. No response to the name being called here in the courtroom. No response to that name being called out in the hall. The defendant has failed to appear. Warrant shall be issued for her arrest. And bond in the amount of unauthorized use of stone bond. Bond in the amount of $10,000, plus she must have a interlock, a GPS device, so we know where she is. She's not in court when she's supposed to be. Julio Ramirez, court before. 24 CR 1277. Mr. Ramirez? Yes, sir. Okay, this one is an initial appearance. You are charged here in clause number 24 CR 1277 with the third-degree felony of failing to comply with sex offender registration. So that carries with it up to 10 years in prison if convicted. Serious, fix it. She's going to help you guide your way through this minefield.
It's my first time interacting with him, Judge, and I do not have any of the portal or the evidence. So if you give me, I realize it's older, but I do not have any interaction with it yet. So if you'll give me a 4-week reset to get those things.
Okay, does he know how to contact you and you
Yeah,
know how
I've
to
given him
contact
the
him? So
Yes.
we're not meeting for the first time when we're supposed to be in court? Or because we're not getting anything accomplished here.
Well, there's just an initial appearance.
I understand. I just want to, but you've not talked to her before? See,
I don't have any way of contacting them
Well,
until I meet them.
did you know she was going to be appointed to represent you? Okay. All right, 4 weeks?
Yes, sir.
Get a resending. Andre Guillory.
Thank you, Judge.
And this is 22-40681. And Mr. Guillory, that's you? You have to speak out so she can hear. You are charged here with a third-degree felony of theft, so that carries with it up to 10 years in prison. And yes, so what are we going to do today?
He retained me yesterday.
Very good.
So
Announcement
it's just,
in 4 weeks. Announcement set in 4 weeks or earlier, whatever direction y'all want to go in.
generation will be later.
So just, you'll meet with him here in a minute and he'll go over some things with you and that will be your attorney. And I'd follow his advice because he's a smart guy.
Thank you.
Okay. Please give us some things. And we have Ray Wise. Mr. Wise.
Yeah.
25 CR 29. That's you?
Yes, sir.
Okay. So you probably know you're charged with this indictment with a state jail felony of theft. It carries with it up to 2 years in the state jail. Do you have a lawyer?
No.
Yeah, they come in handy when you're charged with a criminal case.
Right.
Are you able to hire somebody?
No, sir.
Why not?
See, the money.
Yeah, well, I mean, you're not working anywhere at all?
I own the business, yes, sir.
You own a business?
Yes, sir.
How's it doing?
Not very well.
Okay.
That's what this is from. That's a
Is it?
bill from my vendor that's not paid.
What kind of business is it?
Automotive repair shop.
They still make vehicles out there, don't they?
Yeah.
That's the way people get around.
Yeah, it's just, started.
Where is this, in Botown?
No,
Is
sir,
it-
it's in Beaumont.
It's in Beaumont?
Yes, sir. I live in both of them.
You live in Beaumont.
Yes, sir.
All right. You're gonna need to fill out an indigent form. I'll sit right over there, fill it out, and then I will review it. If
Okay.
there's if you're unable to hire lawyers, someone will be appointed to represent you. But the taxpayers are paying for indigent defense, and I'm kind of sensitive about taxpayers since I'm one as well.
Right.
I mean, I gotta pay my way.
Right.
Everybody's gonna fix problems when they have a problem.
Yes, sir.
By
And I mean, I'll.
sometimes it costs. You seem like you understand that.
Yes,
So
yes, sir. I reached out, I called a couple of attorneys and they come in, it's more than half this bill.
I understand, yeah, yeah, well, yeah, we're talking about up to 2 years in the state jail. How much is that worth to you?
That's,
Yeah, they come in handy.
yes, sir.
Lawyers, then you got to charge criminal for it. But this, whatever this cost is, I'm gonna expect it to be paid back to the county somehow.
Right.
So, you gotta figure out how to get those cars repaired. And after yesterday, you ought to have a big old long line of people.
Yeah.
Trying to fix flooding and
Right.
issues and things like that.
Yes.
Anyway, you just need some indigent. You see that right there? He's, just sit right there in the jury box, fill that out, let me know when you're through. Thank you, sir.
Well, this is Wednesday stuff. That's great. Not you. He's got money if they are.
Okay, we're gonna fix, okay, all right, we'll deal with her and just have a seat. Thank you. We're gonna go into this 9:30 docket here. I'm gonna start off with a Logan Birdsong. Logan Birdsong. I need some files out of that one.
Judge. Yeah.
Um, 24 CR 341. This is you are Logan Birdsong, sir, here with Mr. Walker, your attorney and the state's attorney. This is an announcement. What are we going to do today?
We're here to,
Okay.
it's a difficult place.
Yeah,
And.
yeah.
It's for.
Yeah, it's, this one, it's obviously, this one didn't just get resolved in a minute.
We're gonna have one more final meeting and talk it out, and if we can't resolve it, then we'll put it on the trial docket.
Okay. How much time?
I'm happy to be at the bottom.
Please.
I did,
I
I
think
was,
you can expect him to be there.
I don't care if he's there or not.
What, how much time do we need? Is 3 weeks gonna be enough? You're gonna have that
There
done,
for a week, yeah.
How will be.
Yeah,
3 or 4?
let's do 4 just in case. Make sure his schedules, because I know his schedule.
That's not.
He's gonna reset it. Thank you. Gerardo Galvan,
Yeah.
we missed with Gal, the next one.
I know it was here because of an accident.
You lost your client?
I didn't lose.
Just in a few minutes?
He hasn't found me.
Gerardo Galvin? Was that you, sir? Coming in, that man right there?
Might be.
Yeah, that may be him.
Mr. Galvin?
No, he's here.
It's not you, sir.
No.
Gerardo Galvin? You lost your client. Just like that, just a few minutes?
He
was here.
He hasn't found me. Sitting at the passport with us.
This one is an announcement.
Just important, the delay of this case has been, we've been patiently waiting, as the state has been patiently waiting on any urine test results which we have received, and I'll let you go from there.
And Mr. Walker and I have talked about this case. I still need to meet with the victim and talk to her after getting the toxicology results.
Okay.
Judge,
Going on 2 years.
Yes, I'm aware,
The
Your Honor.
indictment.
We just got the toxicology back right after the last resetting.
That's been, Judge, we've been waiting and they.
So, what is, resetting, 4 weeks?
That's-
You think that ought to do on this? Yeah. Seems, okay, reset 4 weeks, please, thank you. And that's on another announcement. Mr. Walker, will that be an announcement? Is that what we want to call it?
Yes, sir.
It's not, I'll do that.
Okay, so great.
Yes, sir. Okay. We'd like him to be disposed one way or the other. Christopher Kibbe, Chris Kibbe.
Yes, thank you. So.
Morning, Mr. Kibbe here, you've got this first amended motion to revoke now. It's been filed, I guess that's the most recent in April.
Yes, sir. And Judge, I will tell you, I've visited with the state. This case will be resolved. I'm working with Galveston. That's important notice on 2 new cases. One DWI with a child passenger, the other was possession of a firearm by a felon.
With this defendant?
Yes, sir. Yes, sir. Okay. And we have a bond hearing, Judge.
Okay, he's got a case in Galveston County.
He's
too.
got 2 cases wrong.
What do we do in this one?
Well, I will tell the court that it's going to be a plea. What I would like to be able to do, I've got an offer in the case. Give me time, I'm set July the 3rd back in Galveston Street. What I would like to be able to do is work it out.
Yes, sir.
And have it work 16 with Wolf, work out with the state. That's all we need to do.
So today then, today's June 17th, 4 weeks?
Yes, sir.
Is that puts it in a good spot for
Yes, sir.
resolvement?
And Judge, out of fairness, I anticipate a plea on the.
Yes, sir. Okay. Yeah, it's got several grounds there that,
I think.
9.
Yeah.
And there's not. I have we received any more reports about, from the SWAM device? Because we got that alert in March. And we hadn't had a problem since then, right?
No problem.
No, you're no problem since then.
The first day.
Because that would be catastrophic. Yeah.
Yeah.
First one, shame on you. The second one, shame on me.
Yeah, I'm good.
And, all right. Okay, 4 weeks. Thank you. Good resetting. And Lawan Kurtz. Lawan Kurtz, Mr. Walker's.
How it fits.
This is actually.
I'm gonna give you a copy of that.
Lawan Kirk, please. Lawan Kirk. Okay.
Are we doing that today? Okay, do you want to just hold on it real quick and talk to her? What you reckon? Like, I don't have a, whatever she can pay. What, I guess whatever the restitution is. That's what I mean. I mean, it's realistic for her.
I think what we're thinking is go to, I think. If I don't really, if it's one of quickly sent back, but I don't know what who's getting just. So if you can.
So Judge, here's the situation. We have an agreement as to the type of plea, most likely, but what we have a disagreement of is of the amount of restitution. And so we're both in agreement that we're going to set a hearing for the restitution determination in front of the court.
Okay.
However, what he's saying right now is that the amount of restitution would affect, from their perspective, how much time they would ask for the length of probation. Because there's some amount that, I guess if it were lower, that she would be able to pay in a certain amount of time. And there's some amount that if it were higher, she'd be able to pay in a lengthier amount of time. And so what he's suggesting right now is that it would be an unagreed plea in front of the judge, and then we would reset it for a PSI and a hearing on the restitution.
Generally, from, you know, I know other judges did the same thing. And learned from other judges, but on that's the victims being repaid and put back whole. That's our foremost concern. The quicker people do that, the quicker the reward. There's, what's the point if it's paid back timely and other key items like theft class, things like that, that are completed, why hold it open for years when the way it's fixed is you can pay the people back. Now, if you hurt somebody, like you break an arm, you can't unbreak the arm. You can repair it. It's like money loss is fixable, but the quicker you do it, the more you get rewarded. The people who are out the money, the longer they're out the money, they're out that interest and use of the money. You don't pay interest back. The federal government does. When I was with the federal government in the U.S. Attorney's Office, people had to pay interest on the loss, like a loan, which is more fair to the victim. But we don't do that in the state. So I push getting it paid back, because if it takes a year, they've lost that money and use of the money for a year. So they're still out. Paying the money back as soon as possible is what gets the reward. And that's why I push forward, because it's less harm to the victim, because they're always harmed. They'll always be out something on quid pro quo paid because you don't pay interest on it.
Yes.
What's the amount of loss you're talking?
Well.
Is that still in debate?
That was,
Yes.
that part, and I've had such a difficult.
Well, I'm the arbiter.
Right. So when we've got records, I'll bring the complainants and we can have a hearing, and it should be fairly easy to kind of sort through and determine.
It's a huge judge.
Right. I think on the low end, it's closer to 25,000, and on the high end, it's over 100,000.
Which is what we make the say 30 to something.
150, 30 to 150.
Yes, sir. And so I can tell you is less.
Then.
So I want to make sure, that's what I was just telling Mr. Record. I want to make certain that however I proceed with it, that I don't want to compromising or.
Well, if it's less than 30, then but it's still, it would be a state jail felon.
Correct.
But.
And that's maybe the thing to do, Your Honor, and I'm going to need just a little time to talk to Ms. Burke about it. Maybe the thing to do is to do an agreed plea. Of a felony where I can reserve the life, depending on how the room is.
So essentially, you'd be stipulating to the other elements besides the amount of loss. You'd be stipulating to the other elements besides amount of loss.
Yeah, and that's what I want to make sure that I.
Right. Okay. Either way, I think we've figured out a way where it would come before you.
What do we want to do?
If it's a hearing where I need to prove up, have witnesses available for the restitution amounts, 4 weeks, I think is what we're thinking about. Or somewhere in that range.
You're the 4-week man now, because you'll be doing a lot on that day, but that's okay if you're going to keep that. I mean, we can take care of a lot of business for you.
Couple of days.
No, I think I could do everything in 1 day or less.
Judge, I can have 6 weeks.
Okay, got it. Done.
To me.
All right, reset it for then 6 weeks. Okay. Thank you.
Thank you, Judge.
Please get a reset and thanks.
So that brings up an interesting question that, to be honest, I'd never thought of before. So I'm putting a poll up right now, and you let me know your thoughts. Should a guilty person have to pay interest on the victim's loss as part of restitution? The concept has never crossed my mind, but it's a curious one. So let me know. Let's go to Centerville, Michigan, to Judge Middleton. He's had a very, very busy morning.
This is Judge Middleton. What's your name? Scott Lee Trushel. All right, Mr. Trushel, you've got some friends here in the court. They've been waiting patiently all morning.
Hey, I can't see you guys.
Well, they're outside of your vision. They're not in the camera view,
You, I
but they
can't
are.
even see you.
Can you see me?
Got you. I got you.
All right. Your lawyer, Rhonda Ives, is here with me. Also, Chief Assistant Prosecuting Attorney Joshua Robert. The complaint here alleges that on or about June 5th in the city of Three Rivers, you did maliciously destroy or injure a police car belonging to Three Rivers PD. That's a felony punishable by up to 4 years imprisonment and a fine of up to $5,000. You're also charged with resisting and obstructing that same officer, which is a felony punishable by up to 2 years imprisonment. You're charged with being a third habitual offender, alleging that you have at least 2 previous felony convictions, making the maximum on these 8 years and 4 years. Your lawyer advises me that you have waived your right to the preliminary examination on this matter, have the matter bound over to circuit court. That'll be set for a status conference. And she also tells me that you wish to address your bond. All right. Is that true, Mr. Truesdale? You waived your right to the preliminary examination?
Yes, sir.
All right. Do you have that waiver, Sives?
Yes, Your Honor, I will approach.
Keep that.
Oh, you'll keep it?
Yes, they provided to me. I've signed it. We'll process it.
All right, very good. Your bond is set in the amount of I believe it's $20,000 cash or surety set by Judge Pattison with a curfew and pretrial supervision and some other things. At this point, you've been in custody for
Excuse me?
you've been in jail for
13 days.
11 days on this charge. All right, what would you like me to know regarding the bond?
Well, Your Honor, my client is going to need some surgery. It's been pending. He has, I don't know if there's a date certain set for that surgery. Is there a date certain set for the surgery?
Well, I have to go in on the 7th for another scan on my elbow at Bronxton. And then shortly after that, they're gonna do surgery on my CH and my neck and my spinal cord. Because I don't have any grip in my left hand. And it took me 2 months to schedule the appointment to get in on the 7th of July. So if I miss it, then I'm screwed for another whenever they can get me in. But the longer I go without surgery, the longer it's gonna be for me to use my hand.
Somehow that's not my fault. I understand that that is certainly hard to get medical appointments, but you got yourself arrested and now you're in jail, and Judge Pattison set the bond very high.
Sir, I've never missed a court appointment, ever.
Well, that's one of the factors. The other factor is whether you're a danger to yourself or the public. And you and I have been down this road before. 2021, assaulting, resisting, and obstructing a police officer, assault and battery, and domestic violence. That was in front of me. Took a long time to collect on this.
Like I told her, you know, I can probably pay restitution for the window, and I know you guys some fines and costs and cover that before I have the surgery.
It was assault with a dangerous weapon, assault and battery, 2 counts of domestic violence. You never paid the fines and costs in that one either. Defendant doesn't have a job, not able to make any kind of payment, and we struggled with that one. So that's an assaultive crime. Assault with a dangerous weapon, assault and battery, and file 212035 FH. And I'm not.
Sir, I didn't have the weapon. Jack Morris with the baseball bat on that. I didn't have the weapon.
All right, well, you've got a long history of charging with assaultive crimes, including some more recently that haven't been paid. Whether you've always made every court appearance, I guess I can't disagree. But when you get mad, people can be placed in danger. So you got no job. And where would you live if I let you out of jail?
Mr. Moorfield there in the courtroom said he could help me with the place to stay. And I have some part-time work I can do. So I said, I can make restitution on the window and what fines I owe you.
Your Honor,
I
I
don't
think
know.
Ms. Portfield would like to address the court.
All right, would you come forward, sir? Right up to the podium. What's your name?
Waylon Moorfield.
How are you connected to this?
I am a pastor at Daily Harvest Ministries in Three Rivers. And over the.
What's it called?
Daily Harvest Ministries, OTR.
Where is that?
It's right next door to Subway. 205 Main.
Oh, the old Baptist church?
I believe at one time it was.
The big white church?
Yes.
Okay, all right. What do you know about this?
As far as what, I don't know all the charges. I know that I've worked with Scott for almost a year through the winter. Sometimes when the weather gets bad, we could let people stay in the church. We're not zoned to have people reside there. But on occasion, we could have like lock-ins or things of that nature. And I've worked with Scott for a while. I've taken him to several of his doctor's appointments, and I've been with him while he's trying to get these surgeries on his arm scheduled and what have you.
All right, thank you. And they've been waiting here for hours. We end up doing the in custody guys later. But you've got somebody in your corner, I'll grant you that.
Your Honor?
Yes.
And at this point, I cannot guarantee a place for Scott to stay.
Yes, I understand. You endanger your church by letting people live there. They had some issues before.
That was before I took it over, and that's why we schedule it very sporadically.
Okay.
Thank you, Your Honor.
All right, thank you.
Your Honor, would the court allow Mr., if the court's not going to reduce the bond, would the court allow Mr. Trushell to go to his appointment on the 7th of July if he's got transportation?
No. None of this needed to happen. They went to the Merrill Mall late at night, and that's a nice place in downtown Three Rivers, and they don't need drunk, angry people there. We arrived at the area with the subject standing in the roadway near the driveway. We approached the subject, began to take his shirt off, flex at us, yelling obscenities, and let go of his dog's leash. He told me he was not providing me with his information. He continued to refuse to provide identification. He was standing yelling obscenities. Then it came back that he threatened the officers, threatened to cook their kid and eat it. You're right where you belong, Mr. Trushell. Then you went haywire in the car and did a bunch of other damage. All this has to do with alcohol. But I don't like those kind of threats to police officers. You got a history of violent behavior. several previous resisting and obstructing a police officer charges. I am sorry that you're pending these medical appointments, but the reason you're in jail is you. So I'll accept your waiver. When the matter gets bound over to circuit court, you can ask Judge Stutzman to bend the bond, and perhaps he may have a different view of it than I do, but your request to reduce or amend your bond is denied.
Okie dokie. So interesting results so far in the polls. 62% of you say yes, a person, there we go, should pay interest on a victim's loss as part of restitution. I think in theory, I would say yes, because that's equity that's no longer working for them. And they're out of that for as long as it takes to get it back. So I feel it from that perspective. But obviously it's something that would need to be properly codified at a state level. And I think we already have too many laws. So I think I would only be in favor if they found 10 laws to take off the books in exchange. I think that's my trade-off on that. But we'll see how the poll continues to go, and please continue to express your thoughts in the chat. Let's go back to Judge Stevens.
We're tempted, you know. 25 CR 313 is now called the state of Texas versus Charlize Elizabeth Berwick. Am I pronouncing your first name?
Yes, sir.
You were here with Mr. Lane, your attorney, and the state's attorney does the defense. Reading of the indictment and arraignment here. Can we proceed in summary?
She did. This is on the
In summary, this indictment alleges that on or about December 31st, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you were charged with here? An agreement has been reached between the parties that you would be pleading guilty to a lesser included Class A misdemeanor of attempted burglary of a building, which would carry with it up to 1 year in the county jail and or a fine not to exceed $4,000. Kind of ran out of room there. Sorry.
wasn't an art major.
Say that again? You were an art major? The lights must have been off at the buildings a lot.
Abstract.
Okay. The agreement has been reached here, man, where you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length. There will be terms and conditions of probation, which are normal and customary for this. Right. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Understand?
I understand.
How do you plead to this lesser included Class A misdemeanor of attempted burglary of a building, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you. It's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Right.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read. You were guilty of the crime charged, and most importantly, what it says here, and any lesser included offenses, which what you have pleaded guilty to, and what you will be sentenced for, the attempted burglary of a building. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. Correct.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
It's waived, Your Honor.
I'm going to follow this agreement if nothing further and find you are pleading guilty to this attempted burglary of a building, the lesser included Class A misdemeanor under this indictment. You are doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from States Exhibit 1. You admitted to finding guilty beyond a reasonable doubt. And I am going to instead defer any finding of guilt, place you on deferred or unadjudicated probation for 2 years. There is no fine.
Correct.
Is there restitution?
No, sir.
There will be terms and conditions of probation, which are normal, customary for this type of offense. Make sure you follow. If you fail, your probation could be revoked. You could be sentenced to county jail up to 1 year. Okay, be careful. And here's the probation orders. Thank you very much. Thank you. Anything?
No, Your Honor, thank you.
Thank you, Mr. Long.
So Bailey, I'd love to feature you on the show at some point. And matter of fact, it's possible you may guest host, as we have discussed and will continue to discuss. But please don't get on the show for a federal crime. We would laugh and we would cry all at the same time. And yes, Shorts is just Arizona casual. You're absolutely correct, Jim. Jim and Bailey and everybody else, thanks for all the extra information you've been providing regarding some of the things we've been discussing. You guys looking stuff up. That's really helpful for the community, so appreciate that a lot. Let's go back to Florida, and we'll pick up with Judge Garcia again.
And I've met with Mr. Weddle. I've also reached out to Mr. Blunt about some discovery that I'm trying to track down. I'm going to speak with Ms. Parrish tomorrow and her assistant, and I think they may have it. I think a tentative trial date of September would be appropriate because I think there was a couple more depots that needed to be done.
Do you think you can be ready?
I believe so. And
Okay.
I know Mr. Weddle's in a hurry, so.
Oh, I get it. But I know that you're fresh on the case, so I just want to make sure that you feel comfortable in having discussed with him. And if you tell me that, I will give you a trial as soon as you are ready, okay?
And barring any unforeseen circumstances, I think we can be ready by then.
All right. Does the state have any basis to object?
For setting it for trial? No, Your Honor.
All right. Would you like a pretrial in August or
Please,
September?
August.
Ladies, what's my pretrial date in August? August 19th, pretrial, trial September will be? I know you guys give me these cheat sheets and it would help if I looked rather than harass you for it. September 22nd. So Mr. Weddle, your attorney has asked that I set your case for trial on September 22nd. That will be at 8:30 in the morning. And your pretrial will be August 19th, and that will be at 9 in the morning. We will have you either transported in person. For the trial, we'll for sure have you transported in person, but for your pretrial, you may be by Zoom again. But your attorney will continue to communicate with you at the Washington County Jail. Do you have any questions for me?
No.
All right. Thank you, sir. Anything further from the state or the defense?
No, Your Honor.
All right, Washington County, thank you guys so much for making him available on last minute notice.
No problem. Thank y'all.
All right. Yes, sir. Yes, I'm happy to. Just give me 1 second. I've got a special ASA Gomez. Who's on ASA Gomez's? You, Derek? Let me call that real quick, and then I'll do Pittman, and then I'll do Dogle. So Derek on Mr. Blunt, what case do you and Mr. Gomez have?
Your Honor, we have State of Florida versus Mr. Kevon Clemens.
How's that coming? Do you need the case numbers?
It is case number 23435 CF. We are still scheduled for trial in August. if we could have that August 12th pretrial, just to make sure there's
August
no,
12th is private attorneys.
Our-
August 19th is ours.
so we have the
You go
August
with that?
19th. Yes, ma'am.
Mr. Gomez, what say you?
Yes, ma'am. That tracks. I'm good with August 19th pre-trial. And since that's going to be right before the trial, I'm going to try to make every effort I can to actually be present in person in court there so
Sure.
that, I can make sure that I have everything squared away.
Mr. Blunt will probably share this with you, but one of the things that I like to do is do a last plea colloquy, not to get involved in plea negotiations, but to have a clear record. Additionally, August time is really, really tight. So absent you guys wanting to get together on a Saturday for any last minute motions, let me know sooner rather than later if you anticipate pretrial motions, because we're going to get it done, but we might have to do it on some unconventional times, right? So
Yes, ma'am.
Absolutely,
Okay.
Judge. Thank you.
Okay. All right.
Mr. Gomez, if you can get me that video, I think it may help tie up some of those loose ends we talked about the other day.
Okay. Yeah, I'll make sure that we get that over to you.
Appreciate it,
Mr.
man.
Blunt, I'm happy for you to talk to Mr. Clemens. I didn't realize he wasn't
Mr.
standing.
Clemens,
I didn't realize he wasn't standing there. I'm so sorry.
Mr. Clemens.
They're getting him.
Hold on, Mr. Blunt, we're getting him. We had a mix up. My apologies.
Good morning, Mr. Clemens.
Good morning.
What we're going to do is set your case for the August 19th pretrial, and we're still on track for the August trial date. Mr. Gomez is going to get us a copy of that video, and I did complete those depositions of Mr. Davis and Mr. Hartfield at the jail the other day, and I'll go over those with you, okay?
Okay.
All right. Thank you, man. Well, I'll see you at the jail.
All right.
All right. Mr. Blunt, thank you. Mr. Gomez, does that take care of all your cases?
Yes, it does, Judge. I appreciate you letting me appear via Zoom again.
All right. Excellent. Thank you. It's good to see
Thank
you.
you.
Let's take
Good to
Ms.
see you.
Lily Ruth
Have a
Pittman
great
and then
day.
Chiodo. I will, thank you, you too. I'll need Chiodo next, and then we'll get on with where we are. We're here in Jackson County case number, give me 1 second, on Ms. Pittman, case number 25 CF 262. This is the state of Florida versus Willie Ruth Pittman. Ms. Kelly has been appointed to represent Ms. Pittman. Ms. Kelly, the court sua sponte requested an additional evaluation by Dr. Dorico. The court has received that evaluation. Dr. Dorico went to see Ms. Pittman on June 9th. God bless you. 2025. What'd you say?
In the two police station.
Just listen, okay? She just told me.
Okay.
Continue, go ahead, Judge.
Okay, on June 9th, 2025, there was an evaluation and he prepared a report. I have had an opportunity to review that. Have the attorneys had an opportunity to review it?
Yes, Your Honor. Yes, Your Honor. I have no objection to it.
And what says the state?
Your Honor, the state would request that the court take the advice of Dr. Dorico and have her admitted for treatment.
All right. The court not only has reviewed Dr. Dorico's report as it relates to Ms. Pittman, but the court has also reviewed the report that was entered in the Washington County case, a copy of which it was also filed in this case on May the 30th, 2025. That was by Dr. Beltran, and that was an evaluation date of about a month before, on May 19th, 2025. In both reports, both of the doctors indicate that Ms. Pittman is not competent at this time to proceed to a trial or these proceedings. Dr. Dorico's report specifically recommends that she be committed to the Department of Children and Families for competency restoration training. And I will so order at this time. And if we have alternative options, I am happy to consider them from counsel.
Your Honor, Two things. I believe Mr. Pittman is present. Has indicated that he would like
Hey,
to
Mama.
request essentially announce a hearing on his mother's behalf. And additionally, I believe that Mr. Pittman is making headway on placement. I think he had indicated that there was a bed available for her at a nursing facility in Donaldsonville, Georgia. And I have asked him a couple of times to get me the required information so I could get it to the court. But I believe he would like to address the court.
I'm not going to hear from him. He is not a party to this case. And you have been willing to communicate. Is that right?
Yes, Your Honor.
All right. So I will not hear from him at this time. However, I will commit Ms. Pittman to the Department of Children and Families at this time. Ms. Kelly, if you become aware of alternative placements, I will work with the Department of Children and Families and the state to see alternative options. But at this time, this is the appropriate placement. All right. Is there anything further from the state? Anything further from the defense? All right. Thank you. And we will be in recess. Thank you guys for bringing her up. 6-month tracking date, ladies, please.
Yeah, you're right, Ashley. You remember her. We did see her. And there was questions of competency. So interestingly enough, we ran across the answer to that. Let's go to Lenawee County, Michigan. Judge Anzalone has recently come online for the first time today, and it looks like she's going to do a sentencing.
Judge, we had it.
People of the state of Michigan versus run back it. There we go. Bruce Anthony Love, file number 24-218. Let me mute my computer. Quick. Obviously my microphone. Okay. This is the date and time set for sentencing again. We have adjourned it. I have Dan Gumtow appearing on behalf of the Lenawee County Prosecutor's Office and Matthew Murphy appearing on behalf of Mr. Love. We received a sentencing memorandum dated June 3rd of 2025. And Mr. Murphy, you stated you received a response today.
Yes, Your Honor. This morning I received a response and reviewed it prior to this hearing.
Okay, I did have a moment to view it. I have not received it yet, but I'll allow you to argue it, Mr. Gumtow. So when we were previously here, I don't remember how far we got. So Mr. Love, have you had a chance to read and review the pre-sentence report?
Yes.
Okay, and could you move that microphone to Mr. Love so that we pick up his audio good? So you've had a chance to read and review it?
Yes. Right.
Okay, and you've had time to review it and discuss it with your attorney?
Yes.
Okay, are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes.
All right, Mr. Murphy, do you wish, and I'm not talking about the guidelines yet, but do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, that's what's contained in our sentencing memorandum. That was the changes that we wish to make. I think that's where it ended last time, was arguing over the relevancy of the trespass and arguments about that. So we just continue that if those.
Okay, all right. Do you want to verbalize that argument for transcript purposes and the record so that Mr. Gumtow can respond?
Yes, Your Honor. So in regards to the matter, and I understand that the narrative of the offense contained in the pre-sentence investigation report is a summary from the probation department. But again, it's in the pre-sentence investigation report. So we do want to challenge some of it. But again, they weren't there at the bench trial. So I do understand that some things may be different than what we're trying to explain, or the probation officer may have viewed it differently. But the statement that Mr. Love had received a trespass warning back in 2023 from Erie Park, as I explained, that issue, I believe, is central to this, and I don't believe that that's correct. He didn't receive an official trespass warning. Officer Robinson testified at the hearing examination and again at the trial that he had trespassed Mr. Love. We had requested documentation of that. I believe at the hearing examination, actually, Officer Robinson testified that he had just told Mr. Love that there wasn't any documentation that he'd given or provided. We had a a charge, a case against Mr. Love for that trespass. That was the case that Officer Robinson had basically charged him with after this incident that stemmed this case. That on that file, we had requested per the discovery, the documentation from the city of Adrian to Mr. Love documenting that trespass had never been received, and that case was dismissed. So again, our argument being that, well, Officer Robinson may have told Mr. Love your trespass from this park. We're arguing that wasn't an official trespass that could be carried with Mr. Love indefinitely for the future. So that was the argument on that, Your Honor. Does the court want me to continue with?
Yes, but hold on, Ms. Adams, I've sent a message to Tom Moore, but I need a probation agent to log on or come in. All right, go ahead.
Your Honor, and that's also central to this issue because it was that fact. Mr. Love has been dealing with this issue for a couple of years now, himself being trespassed from this city property and not being officially trespassed, not giving an official warning, or I'm sorry, an official documentation because of such. I don't know. I'm trying to get to the understanding of where this is coming from. If it's a policy that's put in place by the city, by the parks, or by the chief of police for Adrian City Police Department. But this policy is involving people like Mr. Love and other individuals in the community are being deprived of their property rights, of dividing their liberty without due process because they have no way of challenging that trespass moving forward. If what occurred here, I mean, this is what my understanding would be that Officer Robinson said your trespass, that trespass was occurred back in 2023 is when he said that. There's no end to that. And Mr. Love, and there's no criteria for that. There's no burden of proof or anything. I believe in this situation that in that incident, Officer Robinson had told Mr. Love, I believe you're drinking in the park and that you can't come to the park anymore. Now, obviously, that's something that I believe officers can tell a person they have to leave if they believe that they're violating the park rules or some other city ordinance, whatever. But that trespass involves them leaving at that time and coming back. They can come back in the future. The trespass only lasts at that point in time. Now, if Officer Robinson believes that he sees Mr. Love with a paper bag or a drink or whatever type of drink and says, I think you're drinking, I want you to leave. And Mr. Love leaves, now that stems, Mr. Love now can never come back to Erie Park. He has, and as it is right now, he has no way of challenging that. So that's, Your Honor, where we're saying that there's a fundamental violation of his due process of not just Mr. Love, but other people in the community, which is the issue here. And Mr. Love was trying to protest that at this time, because if you recall, Officer Robinson testified that he was there in the area, and if you call the body cam, he was reviewing the previous body cam of that alleged trespass that he originally trespassed Mr. Love at. Officer Robinson testified that he was there, and Mr. Love was being loud. He was basically yelling at Officer Robinson. Officer Robinson testified at the trial that he stayed in the area in the hopes that Mr. Love would calm down or something to that effect. But it was his presence that was causing Mr. Love to act that way. That's why I had objected to one of the other statements that the child had said. Mr. Love was only acting that way when Officer Robinson was there. And so Mr. Love was protesting the whole situation, the fact that he can't even walk to the park. Again, he doesn't have a license to drive. His only way is to walk to areas, and he's now being told he can never go to these areas for however long he has left to live, which hopefully is another 30, 40 years. But that's the issue here, Your Honor, was that Mr. Love was protesting that. And that was why I thought maybe the narrative should have been changed to reflect that in regards to, again, what the child had said. And thank you, Your Honor.
Okay, so there is a statement, description of offense narrative that states on May 12, Officer Robinson of the APD observed Mr. Love at Erie Park. He had received a trespass warning back in 2023. And I guess the language, and at this point, I don't know if they're saying that on that day, the officer advised him not to be in the park. But Mr. Gumtoe, your response, please.
Your Honor, the people would contend that the trespass warning given by by Officer Robinson, even if verbal, would be valid. But aside from that, if Mr. Love felt as though he had a valid reason to protest, we would argue that the park was not the place to protest that the courts would have been the proper venue for that. That's our position, Your Honor.
Okay. Anything else, Mr. Murphy? So Miss Holly, I know you're pinch hitting today. So if you go, there's a portion of the PSI under description of offense states that on May 12, 2024 at approximately 1500 hours, Officer Robinson of the Adrian Police Department observed Bruce Love at Erie Park. And it does state Mr. Love had received a trespass warning back in 2023 from Erie Park. So that was a warning. It was never a formal trespass he received. So I think the issue is based on that, it's just kind of convoluted, the paragraph. So I'm guessing it should say Mr. Love had previously received a trespass warning in 2023, period. And then that wasn't the basis to trespass him, is what you're saying this time.
I think it was the basis. That was the whole idea that Officer Robinson.
But it shouldn't have been.
Well, I'm arguing it shouldn't have been, but I think that's what Officer Robinson was going on.
Okay. All right, I think that trespass warning, so he wasn't formally given a trespass charge back in 2023, but there was some dispute at the time of this incident, and then he was trespassed. I'm trying to remember.
I believe the verbal trespass was given in 2023, Your Honor, and I don't know beyond that. It would be our contention that a verbal trespass is enough. It doesn't have to be written.
And Your Honor.
Right, but if it's a warning, it's not a permanent trespass, right?
I would say a warning is probably not a permanent trespass, yeah, based on just the language, Your Honor. I would agree with that.
All right. So I guess, I guess the language in the PSI just needs to state that he had a previous trespass warning in 2023 for Erie Park period. And then the officer.
Your Honor, I guess the question we was that even relevant at this point.
Not really, but
I'll
modify the PSI to reflect that.
Because again, our argument being that their understanding, Officer Robinson's understanding is this warning, verbal warning does satisfy an official documented trespass moving forward. So at this time, still, Mr. Love, if he walks near Erie Park, he's going to raise the issue of the police department. And so that's one of the problems that we have here is while in the PSI, I don't mean to drag this on.
I mean, we can listen to the video again, but my memory, and I've had a lot of cases since then, is that he was, do we want to listen to that portion again, the initial portion?
I don't think we need to, Your Honor, because I think we're just going in circles. The problem that I have is that I guess it ultimately is the officer's belief that he has officially trespassed Mr. Love from these parks, I believe is relevant. But I think we're arguing over the use of the word warning here, which we would consent that a verbal warning was given. The effect of that is what we're arguing about.
Okay. But he was still trespassed again that day and advised to leave the park.
He was told the day of this incident, earlier that day, Officer Robinson said, you can't be at the park. Not for anything else previously, but for that 2023 incident.
Okay.
Not for anything he had done that day.
Okay. Anything else?
No, Your Honor.
Okay. Anything else you wish to explain or challenge in the body of the report?
Nothing further in the narrative, Your Honor.
Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I can think of, Your Honor.
The guidelines in this case were computed to be, let me get back there. They were computed to be 0 to 34 months. Do you agree with that computation guidelines?
I do, Your Honor.
Do you?
Yes, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of the people?
No, Your Honor, thank you.
Mr. Murphy, on behalf of your client?
Your Honor, we're asking the court, we understand that the recommendation is for some incarceration, a year incarceration suspended. I think the recommendation says suspend all the 30 days and maybe probation after that for a period of time. Your Honor, as we've spent quite a bit of time on
I
this.
don't see the suspend. I see 18 months probation, truthful report, 1 year in jail with credit for 3 days served.
And I think at the end it says the remainder of the jail term be suspended.
It's not in that part, it's in the second part. Okay.
Yeah, they split it up. But Your Honor, obviously, there's quite a bit here that I've argued in regards to the fact that Mr. Love, we've had a trial. We understand the situation. Mr. Love understands in the jurisdiction of the court that, you know, the trial and the way it did. But at this time, Mr. Love still contends that he was exerting his First Amendment rights, and I believe that he was doing so as well. Your Honor, with that, I don't want to take up too much of the court's time, but I believe a sentence that would be fines and costs would be appropriate in this matter, or suspending all jail time and just having probation moving forward. Well, Mr. Love, again, he does have a past criminal history. If you look at it, it's, again, driving license suspended and conflicts with officers. And as I explained, this conflict with the officers seems to be far more than Mr. Love. I mean, it's not as though Mr. Love is broken into a house, they come to respond, then he fights with the officers. It's the officers saying you can't be at this park, or you can't walk on the street, or Mr. Love, stop, you know, the video that Officer Robinson was looking at was just Officer Robinson yelling out the window at Mr. Love. Hey, Mr. Love, you can't be at the park. Which, you know, so that's the environment in which Mr. Love is living. That's what he's dealing with right, you know, in Adrian at this time. And so we'd ask the court to take that into consideration when passing a sentence. And I believe, again, the guidelines, they're 0 to 34, which allows a huge leniency for the court and what to do, all of which would be appropriate under the guidelines. So if the court was to do fines and costs or just probation, it's still within the guidelines for the court to do that, Your Honor. So I'd ask the court to consider that.
Okay. Mr. Love, anything you want to say on your own behalf?
Actually, Mr. Robinson, Officer Robinson,
Can you move that microphone, and I need you to speak up?
I said, Officer Robinson has been threatening me, been stalking me for the last 3 years, you know what I mean? I mean, I can't walk out my house, he parked in front of my house, I can't walk my backyard, he behind my house. And he's doing too much, you know what I mean? I'm not the bad guy here. I just lost my mom. I'm still in recovery mode, you understand? And there's so much that he done put me through. All the money I had is gone because I had to pay all these court costs, different things that I ain't have no money for. But because he made me feel like I'm the bad guy, but which ain't doing nothing wrong. He kidnapped me, actually. Understand? Man, why is it 3 of us? He always come up to me. Okay, who around? It's always me. I don't appreciate it. It's not right.
Are you, no, you have a cane, so I asked this, are you receiving Social Security?
Yes, I am. Let's go.
Your mom's funeral over?
Yeah, we got a lot of stuff. We got to move down south and take it out.
Is that all done?
Yeah, we ain't done yet. We just, I'm trying to get there, and I'm starting coming up here. Like every time I go, like I'm coming back. You know what I mean? It's just so much of it.
All right, so this was a bench trial. The body cam, once it was turned on, actually was pretty good video and audio. So court did find him guilty. So, Mr. Love, you have a lengthy record, and Mr. Murphy's correct. It's not major offenses you've been convicted of. So in determining the case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So it is a sentence of the court that you be placed on probation for 18 months. During that term of probation, not to violate any criminal laws of any unit of government, not to leave the state without permission of the court. Obviously, if your mother's funeral is going to be occurring, you'll just request permission. They bring it to me. Okay. Make a truthful report as required to the probation department. Notify them immediately about any change of address, not to engage in any assaultive, abusive, threatening, or intimidating behavior, not to use any object as a weapon, submit to search of your person and property. That includes your vehicle, your residence, your computer, without need of a warrant if they have reasonable cause to believe you have items that violate the conditions of your probation. They can't enter your house for probation, just to verify you live there and enter your home for that. There's a crime victim assessment fee in the amount of $130, $30 per month supervision fee, $60 if they need to put you on a tether. Court costs in the amount of $350, $60. I don't know that we need a DNA fee. He's been on probation before, but if they had to redo the DNA fee, it'd be $60, $68 in state costs. So what I'm gonna do is give you 1 year in the Lenawee County Jail. I'm gonna suspend that. And I'm not gonna take him into custody today. So Mr. Love, I'm gonna suspend that year in jail and I'm gonna give you 3 days credit. Your guidelines are 0 to 33 months. So understand if you violate probation during that term, you're gonna do a year in jail, right? So you do have the right to appeal this sentence. My bailiff's gonna hand down to your notice of right to appellate review. You're gonna sign 1 copy for our records to acknowledge your receipt of the documents if you wish to appeal your sentence, which I think there's some discussion with your attorney about something, but you need to fill out the paperwork and submit it within 42 days. And I think Mr. Murphy could help you with that. I asked about Social Security because if I was going to give you a jail term, it would have been less than 30 days because I didn't want them to stop your Social Security and make you have to reapply for it. I'm sure Mr. Gumto is not happy with me because usually on these we do give a jail term, but in this case, I'm not going to today. So will you initial and date that? Just acknowledge you received your paperwork.
Thank you, Your Honor.
Thank you, Judge.
You're welcome. Record to reflect, I received back a signed copy of the notice of right to appellate review. All right, we're all set. Thank you.
You need to report to Mr. Moore Tuesday.
Tuesday?
Yes.
So between 8 and 10, report to Tom Moore across the hall, all right?
Thank you.
Thank you.
Okay, so we'll do a little bit of overtime. Why not? Let's do that with this guy, Judge Stevens.
For not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case, you would be guilty and placed on deferred or unadjudicated probation, which can be up to 5 years in length. And it looks like another case is going to be dismissed. Is that on my docket?
No, it's a misdemeanor case, Your Honor.
It's a misdemeanor. And then there will be terms and conditions of probation, which are normal and customary, plus you have agreed to forfeit the weapon to the state of Texas. Is that right?
Yes.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Also, you're going to, did I say $500 fine? Yeah.
Yes,
There's a $500 fine involved here too. How do you plead to this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. The state you were mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states she'll help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes without objection.
No objection.
It is so done. Pre-sentence report waived.
Yes, sir.
I'm going to make the following findings. You, sir, are pleading guilty today voluntarily, and you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked. You can be found guilty and sentenced up to 2 years in the state jail. You must pay a fine of $500. Also, you shall be ordered to forfeit the firearm, which is,
It was a different firearm, Your Honor. It was, he's talking about the misdemeanor firearm.
okay. Can you
This firearm didn't,
identify it? Do you know what it is? Because it just says a firearm. It just, there's nothing to identify specifically what we're talking about. I see.
Let me look in, I can probably find out for you real quick.
Okay,
So, yeah, a quick answer today.
hold on. I then detained had not to retrieve the panic handgun from his waistband, at which time he
That's good.
informed me of an additional handgun, a 6 Sauer, also in the waistband.
I got on both participants, look, Judge. That gives you the serial number on both, Judge.
I know, but which one is the one that he's forfeited?
he should forfeit both. One of them was stolen, so he doesn't have any right to it. And that one, I believe, is the 6 Sauer.
So that's for both of us. With the serial number.
What do we put in there? What do we put in the probation order? He's gonna forfeit which one, and he's forfeiting one and returning the other to the rightful owner? Is that right?
He don't only the one. He don't only the one. So really, they both.
Both will be forfeited?
Yes, Your
And
Honor.
return to the right home.
Okay, they're going to be forfeited to the state, and it is a, here,
And then return to whoever was the actual owner.
okay, it's a Canik TP 9mm firearm and a 6 Sauer 9mm firearm. And we'll give this to the probation officer so she can identify, have it identified in the probation order. Anything else?
That's it.
All right. Thank you. Please see the probation officer.
All right. Mr. Xavier Ingram. He's a plea as well. Sir. Probation officer.
Xavier Ingram is now called in 24 CR 2387.
Come up, Mr. Ingram.
That's you?
Yes, sir.
I need Mr.
Oh, sorry.
You know, I don't memorize these, and I gotta have these still.
You didn't do nothing.
24 CR 2387 is called Xavier Ingram.
Yes, sir.
That's you? With Mr. Adams, your attorney and the state's attorney does the defendant with a formal reading of this indictment. And the arraignment here, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on about October 21st, Halloween night here, 2024, in Jefferson County, Texas, you committed the second-degree felony of bribery. And you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years in prison or less than 2 years in prison. In addition, you can be assessed a fine up to $10,000. Do you understand? Yes, sir. Agreement has been reached in your case that you would be pleading guilty, placed on deferred or unadjudicated probation up to 10 years in lieu. There will be terms and conditions of probation, which are normal and customary. Is there any loss of money here or something?
No, sir.
Okay. This says Jefferson County JCDI. Tell me out, what's, it's
That's
written
the
here. I know
drug-
what that is, but why is it in here?
If you look at the PC, Judge, it's very clear there's a drug issue here that's underlying this offense.
But probation office is going to take care of this today, but they're going to do a kind of a post-sentence investigation to determine what issues we may need to address in addition to this to prevent further criminality and for you to do better. So there may be additional terms and conditions other than what we're going to be setting forth here. If I follow this agreement, you have no right of appeal of your case. Do you understand? Yes. How do you plead to this charge, guilty and not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes. I'll show you here what's marked as State's Exhibit 1. Did you sign that doc? Help me. Thanks, Lexington. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are incorrect? Yes. State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, the state you are mentally competent to enter this guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged in any lesser included offenses. You are giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by your lawyer. All true, so help you God. State's Exhibit 1 made a part of the record. For all purposes, pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir. Nothing further and find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to instead defer any findings of guilt, place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it will be shortened to 1/3. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, you shall be ordered to attend and successfully complete the Jefferson County Drug Intervention Program that will be supervised by the probation office. Make sure you follow these requirements. If you fail, your probation could be revoked, you could be found guilty, and you could be sentenced up to 20 years in prison. Do you understand? Fix this mess. There you go. Thank you so much. Please see the probation officer.
Thank you, Judge.
My God, you're gonna go on and go some speak to them. When you make this, you. I don't still there.
Ben Johnson, you said?
No, this is
That's all.
This last two.
Okay, here's this phone. And Brandon?
Yes.
Mingo? You were charged here in this indictment 25 CR18 with a 3rd-degree felony of evading arrest or detention with a motor vehicle. Mr. Adams is your attorney. What today?
Judge, I think it was back I explained better, but the initial offer was great probation. I understand the state can no longer do that at all. For their policy, it had nothing to do with Mr. Larry, but their policy.
Has to do with the circumstances of the offense, because the officer was injured in the wreck,
So what happened was the initial offer was for straight probation. He was going to accept it, but now I know with the officer being injured, the officer capped for 5. So he's telling me now that he's gonna hire his own lawyer for the next appearance. That right? Can you tell me he's gonna hire you on?
Who?
I have no idea.
No, I'm asking you, who are you hiring?
I'm not hiring. It's my family lawyer.
Oh, okay, your family's gonna hire somebody to help you.
So, once again, all cell phones off.
When that happened?
He said you're gonna be here the next court date.
Cell phones, ma'am,
Okay,
your cell phone off, get it out of sight.
until such time. There's a big sign that says, don't bring your phones in. I know everybody's got one, but when it's on and I can see it, then you can be held in contempt of court. And we can also take the phone and give it to the Humane Society. Let them use it. Don't misuse the phones. Don't record in here or else that'll put you in jail. Go ahead, what else?
So, like I said, I mean, he said no to the cap, and now, like I said.
Okay,
So,
okay, so what are we going to do?
he said he gonna hire a lawyer, so I was.
Is that right? Okay, how much time do you need? You say 4 weeks, maybe?
I said the next court date,
4 weeks, good? All right, I'm gonna reset it for 4 weeks. He's still your lawyer until such time you get a replacement, okay? Here we go, get a reset. Thanks.
And then my last one is Middleton and Cheeseville.
Areas?
How I did next one.
Wilson, please come forward, 24 CR 2123. Okay. Professional bail bonding was still taking care of your bonding? Yes. Is that right? Okay, because there was an issue before, if you were somewhere else, now you're no longer there.
Yes, sir.
And, okay, you're charged here with the state jail felony of theft and which the states in the indictment that occurred on or about August 14th, 2024. Was this the one, who's on this? Was the state going to re-indict this? Is this one y'all? Who is this? On Arias Wilson? Who's the prosecutor on that? Okay. Because you have an enormous amount of theft convictions. 8, we count here. Every time you steal a pack of gum, it's a felony. You understand? I mean, if it's a pack of, it's going to be a felony. Every time, the rest of your life. But also the way this, you have these convictions out of the 252nd District Court and in 2016 and a 2023 conviction out of Fort Bend District Court. I don't know if the state's intending, we had something come up the other day where we had a group of these and it was a state jail felony, but the state intended to enhance the punishment because of the prior felony convictions that were in sequence. I don't know if this was the case or it was some one similar to this. But is there a plan to enhance the punishment?
It was not my plan at this moment, Your Honor, to enhance the punishment.
It is enhanceable though, right? Is that?
I believe so.
Okay, which in the, if it was in, if that last one is in sequence to the 2016 cases, you could be looking at up to 20 years in prison as a potential. If it's not in sequence, then 2 or more felony convictions can boost this to a 3rd degree punishment range, but it's still a state jail felony technically, but the punishment range could be higher because of those 3 prior felonies. So y'all need to look into that and see where we stand today. What are we going to do?
The current offer in this case is 2 years straight probation. I'm sorry, 5 years straight probation with 624 restitution.
As it's just a flat state jail
And
felony?
that'd be a flat.
Okay. So y'all signing up or not?
So do you still want to call or you still want to call?
Okay, that's okay. Great. It'll be set for trial and
I really
will the state, I don't know. You know, you can hire anybody you want.
Okay, I didn't know.
You can hire anybody you want. He's appointed to represent you. You don't get to, you get a competent lawyer, that's him. You can hire anybody you want. But if you're able to hire somebody, why are you telling me you needed an appointment? Because the taxpayers shouldn't be paying for your mess. You're supposed to pay for it, like I should do when I make a mess. You understand? The taxpayers aren't going to foot the bill if you're able to hire somebody. But if you're able to hire somebody, tell me immediately, because we're not going to be continuing to pay your way. Do you understand?
Yes, sir.
What 250,000 people tell me all the time. They don't appreciate that. So pay your way. But I want the state to look into whether we're looking at 20 years in prison or just 2 years. Okay. And we'll set it for trial. I'll get it set for trial. Thank you. That's all. Get a trial setting. I have, is Mr. Jeffries here?
Same judge. I'm gonna play judge.
That's your profit.
Sir, what is your name?
I'm here for Dustin Coleman.
Okay, I don't see your name on the. Yes. Say that again.
Dustin Coleman.
Okay, there you go.
I'm here for a reset if we just want to call him up real quick. Thank you, Judge.
24 CR 1887.
I appreciate it.
Yeah, welcome. I
haven't been in
Have
this
you ever been
courtroom.
for- Okay,
Not
where,
this one.
tell me
I'm
where.
from Austin.
Austin.
Yes, sir.
Okay. You see any rain yesterday?
I did. Yes.
Could use it, huh?
Yeah.
Okay, you are Dustin Coleman. I need Mr. Coleman's file, please.
I've discussed this with the state. We're going to
How's that
reset
working?
this. Good.
Good.
Just reset this for 30 days for a plea.
Okay, as you know, sir, you're charged with the state jail felony criminal mischief, which carries with it up to 2 years. Can carry with it up to 2 years in the state jail, and it's serious. It's important. And Mr. Comerfield here seems like a competent man, so I heed his advice, and he's your lifeguard. He's going to save you from the deep end of the pool here. How much time?
30 days.
You got it? 4 weeks? 4 weeks?
That works.
We'll say it for 4 weeks. Please get a resetting. Thank you.
Thank you, Judge.
Yes, sir. I've got Kevin Johnson.
Ready, Your Honor.
Come on up. Kevin. I'm sorry. Johnson, please. Thank you. Thank you. 24 CR 1671 is called. You were Miss Johnson.
Yes, sir.
Yeah. Present with Mr. Dussel, your attorney, and the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes.
In summary, this states that on or about July 5th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
Agreement's been reached. You will be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. Is that your, and there will be terms and conditions of probation, normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
All right. I'm showing you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
And evidence without objection. It's admitted. This states you are mentally competent to enter this guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're giving up your rights to a jury trial, the rights to the appearance, that's examined, confrontation of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. State, so help you guys. Correct.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is out. I'm going to follow this agreement, ma'am, and find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. We can shorten it to 1/3 of that, 3 1/3 if you do well. And there will be a fine of $500, other terms and conditions of probation, which are normal and customary to this type of offense. And I'm going to sign this and you'll meet with the probation officer. And begin probation. Good luck on this.
Okay, we'll go ahead and leave court for today, but before we go, I did want to point out that yesterday we started adding more merchandise to the Courtroom Files store. We take our time with this stuff because Mrs. TCF and I have been selling goods and services for a lot of years now, and we don't allow for junk, so we pay a lot of attention and spend a lot of time on this. We have more to add, but we've added about a dozen or so items. My personal favorite right now is this Litigate Like a Legend hoodie, which I just love. The good graphic on the back, and on the front we have this sprayed on TCF logo, which I think comes out really cool. Bailey says he loves the tumbler. Yeah, I like that tumbler a lot too. So please check it out, courtroomfiles.com. It's a great way to support the show and get yourself something really cool. And again, we're going to be adding more and more stuff as the days go on because we've got a lot of designs that are in the works. So please do check that out. I have to admit, it is a sad day here at the TCF bunker. If I may be allowed to share for just a moment, we have a loss today that we're dealing with. Specifically, it is the windshield of my car. It's actually kind of a big deal for me. The car is 12 years old, and that windshield in that car is the original windshield, which if you're in Arizona, that's a very rare thing. That car's gone through several sets of tires. It went through a front-end collision. The head on the motor has been replaced because a coolant failure caused it to warp. At one point when I was up north with it, a whole bunch of stuff fell off of a truck that was in front of me, and I had to throw it up on the sidewalk to dodge what was going on, and blew out a tire doing that. This car's been through a lot, but somehow that windshield survived it all. So I was really sad a while back when we were driving down the highway, took a stone, and it just instantly cracked. So I'm very sad, but life will go on, I suppose. My goal was to get that windshield all the way until that car finally died, and I didn't make that goal because that would have been something amazing here in Arizona. Anyways, enough of that. We're going to go ahead and leave it there. I'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. If you are not a channel member, I will implore you again to give it a try. I don't make millions off of it, but we have a lot of fun, and that money goes right back into the channel. Today, we actually spent some time reviewing some of my earlier work in the law community, and I think everybody had a good time with that. So yeah, go have yourselves a good Tuesday. Again, we'll be back tomorrow. In the meantime, do your best to enjoy everything that's in front of you, and ignore those things that aren't as enjoyable, I suppose. But take care. God bless. We'll see you tomorrow.